the Office of the Information Commissioner. I'd like to welcome both our active participants here and those in cyber world. As already stated, name is David Gray, and I will be leading you on the area of the Office of the Information Commissioner. What I'm going to try and do today, I'm keeping it very simple. I'll go to my core function, which is law. And what I'm going to try and do is carry you through some of the critical terms in the Act, critical sections, the critical terms. Then we're going to carry you through two of the most important terms that you will come into conjunction with. And then we'll have a talk about how we head into November 30th, 2023, which is D-Day. And so the first and foremost thing is the Data Protection Act. Our Act number 7 of 2020 was signed by the Governor General on July the 10th, 2020. December the 1st, 2021, the Honorable Minister brought into operation several sections, 24, 56, 57, 60, 66, 74, and 77. In broad terms, as well as the first schedule. What those did was establish the Office of the Information Commissioner, as well as appoint the first Information Commissioner. The Data Protection Oversight Committee, which is the committee which marshals the Information Commissioner, was also established and the members appointed. Okay? Now, what do the statutory provisions cover? And this is the Act itself. This. And this is the Act for come on the street with. You know, the one that you work with is all marked up, all color-coded, indexed. So the brief area, the preliminary, which just tells you what the Act is all about. The rights of data subjects, and David mentioned that term a while ago, data subject. You and I. Data controllers, quite a lot of you in this room are companies, or if you're not companies, you own companies, or you work with respective entities. Those are data controllers. This is the critical one. There are standards now for the processing of personal data. 8 standards. With every act, you have those who qualify and those who can seek exemption. So there are exemptions to disclosure to data subject requirements. You have your enforcement provisions, which at this stage of the game, I'm not going to spend a lot of time on, because if I frighten you from now, you may become even more worried. And of course, miscellaneous and general provisions, which are mop-up provisions covering all other things. So what's the critical terms that I need you, if anything at all, to come out of this session, is that we look at this very long term. I've taken it exactly out of the statute. I have not abridged it. I have not added a comma to it. I've taken it exactly as it is stated because it is so important. It means any person, you, I, public authority, whether alone or jointly or in common, so it can be a group, with other persons, determines the purposes for which and the manner in which any personal data are or to be processed, and where personal data are processed, only for purposes, note, only for purposes for which they are required under any enactment to be processed. The person on whom the obligation to process the personal data is imposed by or under that enactment is for the purposes of this act a data control. I'm out. So what it says means is every single person who processes data, no matter what the purpose, no matter how they have come by it, they must process it for the specific purpose for which they have gotten the information. And that information must come from some legal enactment or source, which obliges them to process that data solely for that purpose. Okay? And once you do any of those, you're a data. So Info Exchange has taken all of the data of all the participants that are in this room. The purpose for which they have taken it for is for the purposes of hosting this forum. They cannot now subdivide that information to do anything else with it. They can sell it, because the purpose for which they took the information was for the hosting of this summit. Now, what you're going to also understand is, as soon as this summit is done, that information should be discarded. And the data commissioner will be required to know how it is discarded. Right? So a lot of the age-old issues where we would store the data and then we're going to mine the data for a marketing blitz, we have to be very, very careful now once all the sections come into play. Remember, from my initial slide, only some sections are active now, but this is the principle of the act. So be very careful. The next critical term. So you had the controller and the subject. Again, another equally long definition taken straight out of that. Means a named or otherwise identifiable individual who is the subject of personal data. And in determining whether an individual is identifiable, account shall be taken of all means used or is likely to be used by the data controller or any other person to identify the individual. Such reference to an identification number or other identifying characteristic, whether physical, social, or otherwise, which are reasonably likely to lead to the identification of the individual. Again, long-winded. So it's either a named or otherwise identifiable individual. So it could be my name, David Gray. It could be my iris scan, which identifies David Gray. It could be my fingerprint, which is used to identify David Gray. Whatever means, as long as it comes back to an otherwise identifiable individual. All right? Taken of all means used or is likely to be used. So it could be one variable or a sum total of several variables, all coming back to the same identifiable individual. All right? It can be any reference, black, brown, blue, redhead, blonde, any which way, so that it's reasonably likely to lead to the identification of the individual. So there, the two critical terms are your data controller and your subject. One is the one who processes the data, and the other one is the one from whom the data emanates, that individual. Now, Section 6 of the statute itself lays out the rights of access to personal data. But let's understand that the Data Protection Act really only codified something that has already been in existence. The Charter of Fundamental Rights and Privileges covers this whole matter as to personal identification and personal rights. And your identity is one of those rights covered, right? So the data subject is entitled to a right of access to data. One, he can write to any data controller, that's any person who processes data, to be informed free of charge. Not at a charge to him, the statute makes it clear, free. Whether personal data, which that individual is the data is subject, are being processed by our behalf. So I can now write to Info Exchange and ask them about any personal data in relation to David Gray. And they're obliged to give me that information free of charge. All right? Two, if the data is being processed, to be given free of charge the personal data. So that means all the respective fields of data that may have been captured, they're obliged to give me a copy of that free of charge. The purposes for which it is, well, we know the purpose if we're using Info Exchange is for the purpose of this seminar, but they'd have to tell you what the purpose is, why they're keeping this information. So use a bank has certain information, the purpose would have to be for the purposes of bank. If it's JPS, they'd have to tell you what's the purpose. Customer account, billing cycle, whatever it is. But that's what we're talking about. Because you have instances where you have indirect collection of data. So you need to know what the purpose for this data is. Whom, meaning now the recipient or classes of recipient to whom this personal data may be disclosed. It's not a secret. The individual, the data subject, has a right to know with whom are you sharing my information. So that takes care of the rights. Data controllers now have certain requirements that they have to meet and maintain. If it's a company, its address is that of its registered office. If it's the address of an entity other than a registered company, carrying on a business, that entity's principal place of business in Jamaica. So what we're talking about is if it is an entity that is external to Jamaica, wherever that entity is carrying on its business in Jamaica has to be a requirement for that data control. And this information is going to the Office of the Information Commissioner, and it's going to become a part of the data register, right? Registration particulars of the data controller to be included in the register maintained under Section 17 of the Act or by virtue of regulations to be made. There are no regulations at this time, and the register will be in place on or before the end of the transition period, right? But what every single data controller will be required to do is firstly identify the data controller. And this will more than likely be some responsible individual within the entity. Okay? And the data, the registration particulars, which will need to be included in that entity, would be the registered office, principal activities. So I'm going to carry you to the next slide, which is ensure that the data commissioner And when I use the term data commissioner, let me be pretty clear. It is synonymous, I should use the word information commissioner, just to make the act flow equally. It is the information commission. It's provided now with the following registration particulars. I'm thankful that the slide is big enough that you can see it, but I wanted all of it on one slide because these are all the principal things that are needed. The data controller's name, address, and other relevant contact details. So within the entity itself, the data controller is going to have a name, the address, relevant contact details. If the data controller has appointed a controller rep, right? So the entity of itself may have a point person that they want all correspondence to be routed. Through the representative, they may drill down and have a specific officer, right? So you have the controller, overarching, the representative, if it's an entity that may be outside of Jamaica but does business here, and then you have the officer. So it's a drill down. Then you move to a description of the personal data being or to be processed, and the categories of data subjects to which they relate. So the categories of individuals to whom it relates, the information or data relates, and the data that is being processed. Description of any recipients to whom the data controller intends or may wish to disclose the personal data. As I pointed out before, the data that now comes into your hand is for the exclusive purpose for which you have obtained it. So if you are going to disclose it, you have to now indicate to whom you are disclosing it. The names of any states outside of Jamaica to which the data controller directly or indirectly transfers personal data, right? And of course, this is new because we have now taken on the world, right? Now, this particular clause has some inbuilt safeguard in that the data that is being transferred, there are rules about it. Reciprocating countries must have in place protection for data. And this act itself brings Jamaica in line with almost all of the EU areas in the USA that have active data protection acts or data requirements. Canada, several Caribbean islands that also have data protection acts passed, right? So there are rules and strictures, and to ensure the safety and safeguarding of information, that there are reciprocal acts which carry reciprocal safeguards. Where the data controller is a public authority, meaning something that is related to an parastatal government entity, that a statement of that. Again, building the foundation. Because it's all about the data, the use of the data, who can process it, to whom it relates. Now we come to the critical ingredient that having the data itself, there are standards that you have to enforce in the processing of this data. And first standard, there are 8. And I think it was Sunday, I had the distinct pleasure to pen an article that came out in the paper that covered just this alone. And process data, personal data shall be processed fairly and lawfully, right? You guys are more IT pros than I am. But I know from statistics, you know, you can do a lot with data. You can process it to yield half the cup half full as well as the cup half empty. Same data, but depends on the outlook that you require it for. And the standard speaks to that. The process must be, the data must be processed fairly and lawfully. So it must be in keeping with whatever statute that you have used to obtain it. Secondly, and most important, the personal data shall be obtained only for one or more specified and lawful purpose, and shall not be further processed in any manner incompatible with that purpose. Right? So you're using it solely for the purpose for which you have collected it. And having collected it, you mustn't use it for any other manner incompatible with that particular purpose. So what I'm saying is, if you're doing it for a course, and you can't then try to spin it off from marketing, because that's one of the reasons why you have to tell whom this data will be disclosed. Okay? Third standard, the data shall be adequate, relevant, and limited to what is necessary for the purposes for which they are processed. So it means it needs no more than is required for its purpose. So don't go on a fishing expedition in collecting data. If all you require for the purposes for which you are set up is your name, your address, and probably another 2 fields, then don't go down into next of kin, how much children you have, your grandparents' information, whether you're a Jamaican citizen, US citizen, or whatever type of citizen. If it's not required for your lawful purpose, you need not go there. And that's what the standard is trying. Of course, data changes continuously. So the purpose, the personal data shall be accurate and where necessary kept up to date. So you don't collect it in 2001 and you're still using that data in 2023. You must have some process wherein which it is subject to re-verification at periodic intervals. All of those will be decided upon by the controller and the parameters they'll set up, but it has to be kept accurate. Personal data also shall not be kept for longer than is necessary for the purpose. So as I pointed out, Info Exchange collecting all the data for all of the participants here, not longer, shall not be kept for longer than is necessary. You may say necessary is subjective. So it may be up to a year, but 10 years down the road, it may not. Right? Personal data shall be processed in accordance with the rights of the data subject. And remember, just a while ago, I mentioned the rights. Yeah? Meaning the data subject has the right to have access to their information. So when you're processing it with a view to remembering that the person's data, they have a right to know. Appropriate technical and organizational measures shall be taken against unauthorized or unlawful processing, and that the commissioner is notified of any breach. You are the IT pros, so you know the safeguards that are involved in the protection of data. The various two-factor authorizations that you may have, the various segregation of duty requirements that you may have, right? All of this to protect against the unauthorized or unlawful use of the data. Of course, by virtue of the standard, the commissioner, information commissioner, is to be immediately notified of any breach. So if you are hacked, that information will have to be made known to the commission. When, how, what did it occur? And when it did occur, what steps were taken to shut it down? All of those technical details may have to be divulged at that time. Because what the data commissioner, the information commissioner will be required to ensure is that the breach is cauterized. And if the breach is caused by some neglectful act, there are penalties that can be imposed. It's all about protecting the individual's information and their data. The 8th standard, which I alluded to in the previous slide, if my memory serves me correct, where I said the names of any states outside of Jamaica to which the data controller directly or indirectly transfers personal data. Personal data shall not be transferred to a state or territory outside of Jamaica unless that state or territory ensures an adequate level of protection for the rights and freedoms of the data subject. So it's a reciprocal arrangement. And as I said, Jamaica has joined the world by having a data protection act, which of itself allows it to be a part of the international world. And because of our global reach, our global partners, several multinational companies that have headquarters or domiciled in Jamaica, that have collect personal data, this particular standard is critical. Okay? You want to ensure that whatever information is being shared, that there is an adequate level of protection within those other states. As mentioned before, for everything that there's an applicability, there's an exemption. So the exemptions to some of the standards, national security implications, as evidenced by the appropriate minister. I used appropriate minister instead of national security because I am aware that if the prime minister decides to do a cabinet reshuffle tomorrow morning, he could make the Ministry of National Security the Ministry of National Homeland Protection and vest all the subjects underneath it, right? And although I personally, having been in the public sector for 36 years, prefer the appropriate minister because it can be anybody, right? And this is why I want you to have in your mind the term appropriate minister. It's easier when there's a change that you don't have to go back and write over all of your programs and everything to change what should be Minister of National Security to Minister of whatever. You just put the appropriate minister in your coding and you're good to go. That sort of generic. Law enforcement, taxation, and statutory function, of course, are exempt for data protection. Where it's a regulatory activity, there are also exemptions. Of course, free press, journalism, literature, and art. Research, history, and statistics. And some particular statutes make it mandatory that certain information which is collected is available to the public. So where are we now? I've carried you through the critical mechanics. December the 1st, 2021, certain sections were brought into force. It laid out a 2-year transition period, which will end November the 30th, 2023. We're now at January 31st, 2023. By my check, I think we have 10 months left to go. Right? So it's not a matter now of it not coming. It's not a matter of when will it come. It is a matter now that it is here. What should we be doing? Doing an evaluation of the types of information that being captured. Right? So if you haven't started yet, let's head into the office, have a look at the information that we're capturing. I never went into the term sensitive data because data is data, but of course, you know, sensitive data covers your iris scan, fingerprints, facial features, eyes, all manner of things. So I'm not leaving out the health facilities that may have to collect data. Those are sensitive data. So head into the organizations and have a look at types of information that we capture. Secondly, be far advanced in the design of their data, their information system, and ensure that these systems adhere to the standards. Right? Fairly, lawfully, used for the one singular purpose for which it's been obtained. Right? Identifying the criteria, because it could be several, that they will employ in identifying data protection officers. And I'm going to point out to you, don't go looking in the act to see the act has defined who this person should be. It's not there. And then they build out an entire unit around that function, as well as in a small office, it could be an IT professional. It could be. You may find that because it's sensitivity, some people may twin it to all internal audit. Because you want that person, if there's a breach, to have direct line contact to the chief executive officer. So it's gonna take some thinking, and our office wouldn't be the one to tell you this is what it is. As a matter of fact, the statute was silent on what it is. A recognition of you have controllers, you have protection officers, there are standards there. So when you look at the framework, you're going to build out that framework and give that authority to someone fairly high in the level of command. Of course, moving to have in place all the requirements for registration. I remember earlier I went through all of the things that you need to have: your registered office, data controller, your data subject, your data person, their data controller, your data protection officer, all of those variables, what type of information you have, all of that. Those are critical ingredients that are going to have to go towards your registration. And at the appropriate time, you'll be given the appropriate document to complete and so on. D-Day, November the 30th, 2023. Rhetorical question. Are we ready?